Yes, please.
Item number 1 to 3.
Want to say?
Light is good in the chamber.
Mr. Jayanta Mitra is here for some matters. Only fair to point out my learned senior, so
Where is Mr.
he's waiting.
Welcome, Mr. Mitra.
It's a pleasure to appear before Lordship of such a long time.
Yes.
It has been quite a long time since I
No,
last saw you, Lordship.
not only a pleasure but a great privilege to have you in this court. Luminary like you from Calcutta,
My Lord, I'm very grateful to your Lordship.
and known and respected all over the country. But which matter have you come for?
Item number 14, my Lord, is in the list. Is for admission and, my Lord, for an interim order. Very short submission I shall make before your Lordship on this. And I shall request your Lordship to fix the hearing of the appeal on a convenient date to your Lordship.
Are you asking for any interim order?
An interim order is called.
Who's
But
on the
I
other?
won't take very long. I shall very short submission of pointed, absolutely, and I shall indicate to your Lordship what is the point involved.
But are you here only for today?
I'm here only for.
We will take it up just after Mr. Banerjee's matter at around, say after half an hour. Is it all right?
Yes, ma'am. I shall be here. No.
And Mr. Paul, you're on the other side?
No, I am assisting, sir.
In fact, Milords, we are standing on wrong position. But
My friend is on the
I am
other
on the
side.
opposite side. Milords, learned advocate general is leading me in this matter.
Where is he?
Milords, he will join online. He has joined online, Milords.
He's there.
All right. Where is he? So we will take it at around 1:15. We
Yes,
will take
Lord. I will be there, Lord. I will be there.
115.
Yes, call Mr. Banerjee. Yes, please.
No small scale. One judgment, my Lord, on economic policy, then I'll go to other points raised by our learned friends. I'll just place the paragraphs, man. Your Lordship's limited time.
You have placed 2019 4 SCC 17,
Yes, this one is, my Lord.
86 4 SCC 566.
This is
This is 2021, 8 SCC.
This is 2021 8 SCC, my Lord. 511. Just hand over. A very well-known proposition. Your Lordship may just make a note of paragraph 76, 75 and 76. It's a cardinal principle that it is not within, paragraph 76 at page 571. It's a cardinal principle that it's not within the legitimate domain of the court to determine whether a particular policy decision can be served better by adopting any policy different from what has been laid down, and to strike down as unreasonable merely on the ground that the policy enunciated does not meet with the approval of the court in regard to its efficaciousness for implementation of the object and purpose of such policy decision. Why citing this? Because it
Only
has,
if it's unconstitutional, contrary
That's
to
right.
law, arbitrary, malafide.
therefore, if it is not effective, for example, it has been argued that there is no revenue leakage. One of the policies is to stop revenue leakage. Now today, this paragraph, your Lordship is not to see whether my policy of revenue leakage blockage has actually happened or not. Is it effective or not is not the point. Is it a possible policy reason? Yes. That's the reason for this paragraph. I'm obliged. My lord, then next question, different point, my lord, is that because as I find that the main contention shown of all these legal questions, the way the shoe pinches is basically it's on the margin issue. Fight is really about margin. The game is that Mr. Shah's clients, by reason of this, have to pay more, according to them, because of the insertion of this new entity. They have to take care of the new entity. Earlier they had one bonded warehouse to take care of. Now they have an extra entity in the middle. They have to pay more. Sum and substance is really this, the finance argument. So the finance argument,
You
if I may
tell
call
us this, though the attack is on the virus of the notification or the
Right.
validity, while they are judging that, could the court pass orders like for implementation of the notification by tweaking it a little bit?
Yes. I'll answer that in detail. That will be my next question. No, with respect, no. If the implementation of the notification is not proper, for example, what has been given by my learned friend Mr. Shah, 2 judgments of the High Courts of, I think, Uttaranchal and one other High Chhattisgarh, if you find that a policy is not being implemented properly, what happened in that case, for example, was that there was a sole agency who was to give the supply, and it was shown on paper and on documents that that agency, in spite of intent, was not supplying the goods. So the policy it was not the policy, but the implementation that you are not supplying the goods, that was interfered with by the court saying you have to supply the goods. That's implementation, my lord, certainly. But the policy itself can only be struck down on ground of ultra vires, which Mr. Shah has argued, section 19, or in the ground that the policy is completely arbitrary. There is no reason given which can possibly have any sense. There are only 2 reasons, my lord, legally where the policy should be struck down. My lords cannot tweak the policy and change the policy to suit some ends. My lord, then either the policy has to be struck down or, my lord, the policy has to survive. But in this case, with respect, none of those issues arise. The only issue which ultimately arises is, for Mr. Shah has been repeatedly saying that I have to pay more, my margin has gone up, the CBW has come in, now instead of 1%, I have to pay 2%. This is what is pinching him, and this is his real grievance. In support, he has, of course, made constitutional arguments. Your Lordship will consider those constitutional arguments. One more is coming, private monopoly point, I'll deal with. But today, the next point, I'm very grateful Your Lordship has indicated, is that financial loss, if a policy is good, first Your Lordship decides whether the policy is good or not good. For that, arbitrary, no nexus to the statute, section 19, first Your Lordship decides that. If Your Lordship decides the policy is good, then the fact that the policy is causing some degree of financial loss to a private player is no ground for striking down the policy. That's the judgment which I'll give Your Lordship. That's a very well established principle of law, but nevertheless, I'll give Your Lordship the judgment. Ibrahim.
Para 16.
Yeah. Give him the judge. Paragraph 16. What happened, my lord? In this case, particular bus terminal was changed from one point to another in the interests of the public or whatever by the department. And as a result, the person concerned suffered some financial loss. Yes. Now, paragraph 16, Your Lordship sees. The next contention was the order is repugnant to Article 19(1)(g) of the Constitution, according to which citizens must have the right to carry on profession, business, etc. He has not been prohibited from carrying on the business of running a bus stand. What has been prohibited as the bus stand existing on the site being unsuitable from the point of view of public convenience cannot be used for picking up or setting down passengers from outstation journeys. There is no prohibition for the bus stand being used otherwise. Restriction placed on the use of the bus stand cannot be said to be unreasonable. It may be that the appellant, by reason of the shifting of the bus stand, be deprived of the income used to enjoy when it was used for outward journeys, but that can be no ground for the contention. There is infringement of Article 19(1)(g) of the Constitution. There is no fundamental right in a citizen to carry on business where he chooses. Right must be subject to any reasonable restrictions, etc., etc. and this was a matter for the authority to decide the public convenience. So, merely because you have suffered some loss, what is the situation here? Let's take it as the maximum. He has had to pay, instead of, say, for argument's sake, 10% to one bonded warehouse, now he has to pay, say, 20% because he has to pay 10% to the CBW. Let's take a notional case. So what is his loss? There's a giant ISWAI, which is controlling 50% of India's liquor, has to suffer a small diminution in his profits so far state of Meghalaya is concerned. Sum and substance of the matter. At worst, with greatest of respect, if the policy is valid, this cannot be a reason for striking down a policy. At one point of time, I don't want to put words into my learned friend's mouth, it's good enough to concede that merely if the constitutional challenge to under section 19 fails and the other point of policy fails, then merely because he has to pay more cannot be a ground for striking it down. This is very well settled, my lord. So, while your lordship may feel, I am taking an extreme case, that it may be unfair that he has to pay something more to another entity, that even if true, is not a ground for striking down a policy. I cannot re-emphasize this too often. That cannot be a ground. But in any case, one more point I have, that he has not shown the loss. Your lordship knows there's 0% margin in any case. So maybe your lordship should not be called upon to decide this at all. But notionally, assuming my learned friend is right, that 1 year into the future, it may be a 30% margin asked by CBW. If the policy is right, if the policy for stopping of revenue leakage, for improvement of brand availability is right, no amount of loss of profit can impact Article 91G unless it reaches the stage of expropriation and shutting down the business altogether. That's a different level. Nobody has argued that, man. His right to carry on business as a supplier remains. The right of the bonded warehouse to carry on business remains. All the cases cited by my learned friend, all your lordship will go through, effectively involve substantial shutting down of the business of the petitioner. Lordship will go through those judgments. There is no shutting down of the business of the petitioner in this case, neither of the petitioner nor of the bonded warehouse. None of the cases are pari materia with this case. 1% loss of profit. My lord, if 1% loss of profit strikes down the economic policy of the state, my lord, then all the constitutional principles are thrown to the wind. Can't be the case. So, I would request your lordship, in this overall legal position background, not to go too much into, has he suffered, is he paying more, is the customer paying more, is the bonded warehouse paying more. None of these legally are relevant. I will answer each one of the queries your lordship has raised on fact. But at the end of the day, assuming everything against me, the customer pays more, the bonded warehouse pays more, the supplier pays more, doesn't matter. My argument is, in terms of economic policy, revenue of the government, streamlining, etc., if the policy is valid, all these things should not be taken into consideration. As your lordship says, policy challenge either varies because of no power or so arbitrary that the policy considerations have no nexus to the statute. Otherwise not. That's my point over there, my lord. May I cite the next judgment on this Ibrahim on, it's called Viklat Coal, my lord.
1984 1 SCC
619. May I cite this one? The para here, any idea? Para. What's the para? Lordship, kindly give me a moment. Paragraph 19 to 21, my lord. This is a case of coal wagon allotment.
Can we have the citation, please?
I'm sorry, Mr. Shah. My apologies. 1984, 1 SCC 619.
Thank you.
20 minutes most important.
So, paragraph 21 Your Lordship may have come across this situation. These are the priority to railway wagons. So what happens is, my lord, the priority to railway wagons, defense and other sectors are given priority, and then availability is given to other private traders and other things. So as a result of this priority, what happens is that coal traders fall behind in their availability of railway wagons, and so they challenge this policy that it is interfering with their right under Article 19. This is a background. So what the Supreme Court says, my lord, at paragraph 21, the first question we pose in the context, what is the trade carried on by the petitioners? Are they coal transporters? Is it transport of coal their business? So first question is the business of the petitioners warehousing or not? It is not. They are suppliers of liquor. Or are they, their business is not transport of coal. Transport is merely incidental to their business. Assuming that railways had wholly banned transport of coal, could it be said the action violated 19(1)(g)? When the court is called upon to examine the complaint, the restrictions are trade are unreasonable, it is necessary to find out what is the trade or business and to what extent the restriction is imposed upon the freedom to carry on the trade. It is the direct impact of the restriction on the freedom to carry on trade that has to be kept in view, and not the ancillary or incidental effect of the governmental action on the freedom to carry on trade. The petitioners are not transport of coal. They are coal merchants scattered over, and now they complain they are unable to transport coal because the railways have arranged their priorities such that they will not get the wagon. Prima facie appears the petitioner's business or trade as coal merchant is in no way interfered with by not being able to provide transport facility. The railways is not the only, etc. So the point is, what is your business and how much is the area of interference? Is it direct or indirect? Now suppose the policy was there will be one CBW, all bonded warehouses are abolished. Let's take a theoretical case. All bonded warehouses are abolished, one CBW only, supplier will give to the CBW, CBW will give directly to the retailer. Definitely the bonded warehouse can come to the court and say, my business has been shut, my right under 19(1)(g), and your lordship will test the policy whether it is fair or unfair. But what has happened here? Somebody's margin is going down by 1%, somebody's profit is going up by 2%. What is all this with respect? This can't be a restriction on business. Restriction on business can be direct shutting down of your business or interfering with your business. My lord, my learned friends, clients, business has not been interfered with in any way. They are still the largest suppliers of alcohol in the state of Meghalaya to the extent of 60%. They are still earning plenty of revenues. They have not shown their revenues have gone down or affected in any way. There is no locus for this attack on 19(1)(g) at all, because there is no direct impact on their business restriction as defined by the Supreme Court here. Incidental impact will not do. Incidentally, yes, some extra money has to be paid, one more warehouse has come. Incidental impact, Supreme Court has said, is not good enough for 19(1)(g). That's why I'm citing this judgment. May I proceed, my lord, to the next point?
No, but
Yes.
just carrying my thoughts a little bit further.
Yes. I'm obliged.
While making the notification,
Yes.
you have not made any recitals as to why, what wrong,
True.
what
My lord,
mischief,
with respect, that is not always necessary. It's not a statute or a preamble.
all that, what mischief you are trying to get over or remedy.
I appreciate, my lord.
So
It
if
is not necessary that in every notification.
If it is unlawful trading or some malpractice in trading or importation or selling, buying, supplying, etc.
No, I have not. It is not, according to me, not required in law that every notification must give a recital of all the
All right.
purposes.
Now, the effect of the notification is that the CPWD is kind of superimposed
Right.
over the
Right. Your lordship is right,
the general warehouses.
my lord.
Now, there is no other reason for bringing the central warehousing in the
My lord, in our
notification.
affidavit, in our letter to the challenge by
Now,
the petitioners, we have
you-
given all the reasons.
You say on the basis of these decisions that this is a policy decision, the government knows best
Yeah.
what policy to formulate,
Yeah.
and the court is not going to interfere with that unless it finds it absolutely arbitrary or wrongful
Grateful.
or against constitution or the laws.
My lord.
All right. let us take your argument, let's accept your argument. Can or cannot the court sort of direct the government to work out this policy in such a way so that because there is no preamble, no reason why you are bringing it in, so that there is no loss of business, say, for example, number one, commission. There is no diminution in commission as far as the existing warehouses are concerned, number one. And number two, say, as far as another argument made, their right of free importation of foreign liquor, etc. Now they have to take it through the central warehouse. They would have an option. They would say, you supply brand X of Scotland at rupees 20.
Well, factually, that is not correct. I'll answer that separately.
I have an option to take it directly at 19.75.
That situation does not arise. I'll come to that separately. I'll answer that question. Second part separately. There is no change at all in the choice of liquor. Zero. No change at all.
That would not disturb your policy.
No.
But it would.
I answer the second one first.
But there would be directions of the court in working out that policy so that there is no loss or no injury caused to the existing bonded warehouses. Because
I see your lordship's question. My lord, may I answer a little later, but I'll tell the second question I can answer straight away. There is no question of any problem regarding the choice of the brand. I'll come to that later. I'll explain to your lordship. But so far as the commission is concerned, my lord, I would very respectfully submit that will be going beyond the ambit of the court to actually fix the commission rate. That would be really for the government to decide what is the commission rate.
We will not fix the commission. We will give directions that you have to work you have to work the notification in this way. Otherwise, it would be prejudicial or.
My lord, then what your lordship is doing is effectively going into the profit factor of the suppliers.
No.
And see whether the profit factor of the supplier should be maintained. I would respectfully submit that is not the domain of this court. It may be effectively prejudiced to some extent, but if that is a matter of negotiation between the supplier and the bonded warehouse, my lord, that is a question of negotiation between them. Your lordship wants a fixed minimum to be fixed by the government. That's a different matter. I can take instructions. That's another matter. I can take instructions on that.
Not fixed minimum, to work out the policy in such a way. What the central warehouse does is none of the court's business.
That's right. So the question of working out the policy would only mean, if I understood my lord correctly, is the commission which is charged by the central warehouse on the supplier. That is the only question. Nothing else is there.
That don't generally interfere with the business of the existing warehouses and their.
I shall show your lordship there is no interference with the business of the existing warehouses at all. I'll explain the entire structure of this to your lordship in some detail. Your lordship will give me, let me finish this legal point. I'll come back to this and show your lordship. There is no question of any brand availability being affected. There is no question of any price being affected. Only thing which may notionally be affected is the margin, nothing else. I'll show your lordship from a chart exactly how the system works. Possibly, for whatever reason, your lordship has not got the complete picture in respect of how this system works now and how the system worked earlier. I'll explain it to your lordship in some detail. Your lordship will give me that opportunity so that your lordship is satisfied that so far the customer is concerned, there is no difference. The rate is concerned, there is no difference.
So that, Mr. Banerjee, to put it very plainly, that this is a restriction on the freedom to do business under Article 19. So this notification will be worked out in such a way that this restriction will not be unreasonable.
I see. But that has not been argued by my learned friends. My learned friends have said the policy is to be struck down. I am answering that. I am not answering a modification of the policy. That is the court. That's the court's
query. One of the grounds
query.
is Article 19.
I'm sorry?
One of the grounds is Article 19.
Of course.
I have viewed it in that way, but then
Article 19. My learned friend says the policy should be struck down on various grounds which he has given. Legal grounds. My learned friend has not argued, subject to correction, that because the margin is too high, therefore the policy should be struck down. I mean, I stand corrected if that argument has been made.
And also it is so unreasonable under Article 19, it should be struck down.
Right.
That is
now the question, your lordship will kindly consider the question. So unreasonable under Article 19 should be struck down because what? Margin is 40%, 50%, 100%. Where is the so unreasonable? It's a question of fact, the so unreasonable.
freedom of to do business.
My lord, it has to be demonstrated to the court. He is charging today, the CBW is charging 0% commission to the supplier. Your lordship has seen that. So after that, can it be any better mechanism than that he will get 0% from the supplier? He is having to pay nothing. Zero. Minus. So, I mean, your lordship should be getting into the mechanism only if your lordship finds that the commission rate is so very high that it requires interference from this court, if at all.
Working the policy, one of the ways of working the policy is that they will continue, the commission will continue to be zero.
Yes.
Not that today it is zero, tomorrow it becomes 20. So
Very good.
Under these directions, the policy will be worked out.
Commission will be 0% means the supplier will, the CBW will get only 0% from the supplier.
No, you are saying it is zero.
It is zero. At the moment, that's what is being charged. I've shown your lordship the affidavit.
For example, we are not saying we will pass that direction. We will say, we'll make the observation, it will continue to be this. They will not impose unreasonable commission on the...
I'll take instructions. What is reasonable and unreasonable is another matter.
No instruction, Mr. Baji. It will just be our...
observation.
We are not saying that we will pass that on. It's just an observation, tentative observation that it will
my lord, I'm
continue to
not
be
going
this.
to comment on that, my lord. Certainly.
That you will work out the policy reasonably so that there is no loss cost to the existing
Structure. I'll make my submission on that. But I'll show your lordship the structure also in some detail, so that these apprehensions of your lordship are allayed. My lord, may I just cite the next proposition? Article 19 itself, my lord, which they are referring to, is not available to the petitioners in this case. This is STO, CTC para 15 to 18. This is AI 1963 Supreme Court 1811. Mr. Shah. AI 63 Supreme Court 1811. Paragraph, my lord, 15 and 16. Basically says at paragraph 15 and 16 that it is available only to citizens and therefore not to corporate entities. So, a company alone as a petitioner cannot maintain a challenge under Article 19. That's the judgment. Normally what we do to bypass this is to make a shareholder a party, but my learned friend has chosen not to do that in his wisdom. So in the absence of that,
this is Supreme Court at its nascent stage, and the law has...
my lord, it has been followed by this in the case of this very petitioner, Iswai, by the Supreme Court much more recently. I'll show your lordship that also. I mean, it's easily avoidable, but my learned friend has not avoided it. We always make the shareholder a party.
Not
that is the law, my lord, and that is, I'll show your lordship when I show the Iswai judgment, that has been specifically held by the Supreme Court, that in the case of international spirits, it cannot maintain a writ petition under 19(1)(g) because of this particular prohibition. Lordship will kindly make a note of it.
Today I have Article 19 right, you have Article 19 right, he has Article 19 right.
Well,
tomorrow we come together and incorporate a company.
Yes.
So and so limited, where we all are shareholders. All right, it's a separate...
that is the law, my lord. I'll show you, lord. That is the law of the land.
In law. Immediately it loses.
Yes. You have to make a shareholder a party. That is the law. Your lordship will go into it. I'm not being unduly technical. We have done so many writ petitions for companies every day. Second petitioner is always a shareholder or director. That is the law, my lord. I'll show your lordship more recent judgments also. Anyway, lordship will make a note of it. It is not available to him, and since the Supreme Court specifically said in his case, he should have been wiser and made the shareholders petitioner number 2. But he has chosen not to do that. There's no injustice. It's a technical non-joinder of a necessary party by reason of which the writ must fail. Lordship kindly makes a note. This is still the law. I'll show when I place that ISWAI judgment for 5 or 6 separate points. This is one of the points taken. My Lord, next question, my Lord. I'll not detain your Lordship on this too long. My Lord, this is an important question. According to my learned friend, this is very important because he's raised a constitutional question on this. He says that after the amendment of Article 19, a state can hold a monopoly, but the state cannot delegate that monopoly to any private person. The proposition of law raised by him. So that today, if the state runs a central bonded warehouse, that is permissible, but if it delegates that to a private body, that is unconstitutional. This is the argument made. My Lord, may I, this is not the correct law. My Lord, may I straight away show your Lordship 3 judgments on this? It has been decided.
So you want to start with
Khode,
Kude or Kuvarji, whatever you want.
which is early in point of time.
Earlier is Kuvarji.
Earlier is Kovarji, let's have Kovarji first. There's Kovarji here. Kovarji. Yes. These are both liquor cases.
That is all right, because if it carries on functions in the nature of state functions, you
Can delegate them.
like our CSC or WB, SADSCL, like
It
that.
can be delegated, my Lord. But this argument has been made that private monopoly cannot exist in law. So I'll show your Lordship the judge. It's been argued at some length with number of judgments.
But could liquor be equated with electricity, like that?
Yes. I'll show your Lordship. The principle is very simple. If it is by public auction, concept of monopoly doesn't apply. You have it or not? I have one copy of Kovarji.
Yes.
Kovarji's case, 1954, SCR 873. This is a liquor case, liquor auction case. In the context of liquor, kindly comes to paragraph 8 to 10, absolutely clear. The contention, Lordship has paragraph 8. The contention that the effect of these provisions is to enable government to confer monopoly rights on one or more persons to the exclusion of others, and that the creation of such monopoly rights could not be sustained, Article 19(6), is without force. Reliance was placed on the decision of Rashid Ahmed. This has also been cited here by the other side. The decision is no authority for the proposition contended for. Elimination and exclusion from business is inherent in the nature of liquor. It will hardly be proper to apply to such a business principle applicable to trades which all could carry. So, what is true of other trades is not true of liquor, Supreme Court. Now, paragraph continue. My Lord, Commonwealth Australia Bank of New South Wales. Yet it must be that about every proposition, reservation must be made. Lordships do not intend to lay down that in no circumstances could the exclusion of competition to create a monopoly either in the state or in some other body be justified. Every case must be judged on its own facts. Then, at the next page, page 28. Further, it seems to me the argument suffers from a fallacy. Under the rules, every member of the public who wishes to carry on trade in liquor is invited to make bids. When the contract is thrown open to public auction, it cannot be said there is exclusion of competition and a monopoly is created. We are of the opinion the contention, the provisions are unconstitutional as they abridge the rights of the petitioner to carry on liquor trade cannot be sustained. Absolutely clear, my Lord. Apart from the fact that the supplier is not a tenderer for the warehouse in any case, so he has got no business challenging it on this ground. But otherwise also Supreme Court has said, if I the state want to give up my right for a warehouse to a private person, provided it is done by public auction, that's perfectly all right. That's 54 Supreme Court, my Lord. Then more recently,
Mr. Banerjee will continue tomorrow with your matter.
my Lord. I am trying to be very, very short, my lord. I am conscious of the points your lordship has raised. I will deal with them at the end and I will take some instructions also.
So far and to the extent you find them relevant. And
No,
to the
no,
extent
they are
you
always,
find,
my lord, the court's queries are always relevant, my lord. It is for us to persuade your lordship, my lord.
that is the wrong that we make.
Court's query is
That your
always relevant.
lordship knows, your lordship knows. We know
I
nothing.
will try to assist my lord to the extent.
We know through you.
Your lordship, a very kind man. Yeah, this is your section.
We may know something, but then not your lordship knows. We have to be assisted absolutely properly and thoroughly. All right. Tomorrow, huh? Yeah, Mr. Ranji. Same view. Mr. Shah, tomorrow?
Yes, my lord. Great, sir. Tomorrow.
Tomorrow it's okay. Yes.
That you're in this, right? Anyone betting?
All 14. Mr. Mitra, we have another specially fixed matter. So
Lordship.
kindly make your submissions as short as possible.
At what time, my lord, your lordship?
No, kindly make your submissions as brief as possible.
Oh, yes, yes. I shall be very brief. I shall indicate to your lordship what the appeal is about shortly.
Yes.
And then, my lord, I shall take your lordship to the relevant point. My lord, this appeal has been from an order, judgment and order of this court, which was passed on 2nd of June 2025. My lord, that particular order, by that order of the learned trial judge, the court was pleased to hold that the earlier order, which has been passed by Regulatory Commission, Electricity Regulatory Commission, was not illegal and it is justified. We have come up by way of an appeal from that. I shall give you, lordship, the background afterwards. Number 3 issues will arise in this particular appeal, which perhaps your lordship will be pleased to hear at some point of time. The first question is whether the Regulatory Commission had jurisdiction to recall its own tariff order. That is the first principle. I shall give your lordship the short background before. Second issue is whether the Commission could issue tariff order with retrospective effect. That is a very important point which will fall for consideration, on the basis of which, my lord, various consumers are waiting for an answer as to whether an order could be passed by the Commission, whether the Electricity Act or any of the regulations justify that kind of an order, whereby, my lord, the Commission could issue an order which will have retrospective effect. Second point. These are the 2 issues which will arise in the appeal when the appeal comes up for hearing. Short issue, short point. But, my lord, the background is, my lord, rather significant. My lord, what happened was this. I shall give your lordship very shortly. The Regulatory Commission passed a tariff order on 11th April 2023. My lord, kindly note the date. And, my lord, this was for the period from 1st April 2023 to 31st March 2024, for 1 year. The tariff orders are passed at the beginning of the year to cover for the whole year from the 1st of April of the year to the next year, 31st of March. And such an order was passed on the 11th of April 2023 by the Commission. Now, my lord, it so happened that that particular matter, when this order was passed, there were 2 members of the Commission, the chairman and, my lord, another member. Member law. These 2 gentlemen, my lord, hear the matter. But by the time the order was passed, the learned chairman has retired. So the order was passed by only 1 member, the law member. That is dated 5th and 6th of June. That was for the year starting from 1st of April 2024 to 31st March 2025. Now, after that order was passed, my lord, the distribution company made an application for setting aside of the order on the ground that the order was passed by a body which did not have the quorum. That was the point that was raised. And my lord, that, my lord, met with success before the commission. The commission, which subsequently heard that, a sort of a review application, your lordship can say. So, my lord, the order which was passed by that commission, earlier commission with one member, was set aside. And, my lord, a fresh tariff order was issued. My lord, the order that was set aside on the 23rd August 2024, the Regulatory Commission passed impugned order holding that there was patent error in issuing the 5th June and 6th June order. Therefore, it is necessary to withdraw the same. My lord, that particular order was of the commission was challenged by way of a writ petition. That writ petition came to be heard sometimes in the month of June 2025. But in the meantime, what has happened, and this is the most significant part, before the 2nd of June, the writ petition came to be heard by the court, my lord, the Regulatory Commission had passed a new fresh tariff order because the earlier tariff order was set aside. So, my lord, a fresh tariff order was passed on the 24th of October. And this tariff order, my lord, was with effect from 1st April 2024. So, my lord, 24th October 2024 order was passed with effect from 1st April 2024 because the earlier order of the commission of 5th and 6th of June was set aside, was rendered nugatory. Therefore, my lord, a fresh order was passed. Our question is this, my lord. Could the Regulatory Commission have passed a tariff order on the 24th of October 2024 with retrospective effect from 1st of April 2024? And our submission is this, my lord, that he could not have passed the order. Kindly note, in the meantime, the consumers, all these, my lord, steel and iron companies, my lord, they had been carrying on business and, my lord, paying on regular basis without any default. They had been paying the bills.
The rate prior to 23/8/24.
23/8/24 is, my lord, the order.
Prior to. The rate prior to.
Yes, the rate prior to that rate is
Or
continue to be paid.
Or prior to the tariff order 24th October 24.
Right. My lord, on 24th October, with retrospective effect from 1st of April 2024, a huge amount, my lord, of arrear was shown to be payable. And, my lord,
Were you enjoying any interim order in the rate?
yes, my lord, I tell you, lordship, what interim order I'm asking. What has happened is this: in the meantime, my lord, a review application was made in respect of the trial court order. In that review application, an interim order was passed. And that interim order was, my lord, that interim order directing that electric connection to the plant of the petitioner shall not be disconnected till the date of next hearing. So, my lord, interim order continued, and that order was passed on the 17th of June. 18th of June 2025. That review petition, my lord, was dismissed and all interim orders stood vacated on 18th of July. On 22nd of July, my lord, the electric connection to
18 July.
18 July, the review petition stood dismissed. So the interim order, naturally, my lord, which was subsisting since the 2nd of June up to the 18th of July, that stood vacated. Now, my lord, on 22nd of July, the electric connection of my clients was disconnected. On the basis of a bill which was issued, if I may just hand up to your lordship, my lord, a copy. Okay, copy. I shall just show your lordship that this has been annexed to a supplementary affidavit which I have, with your lordship's leave, my lord, I shall file today. Kindly, my lord.
Disconnected.
Yes. My lord.
Line is disconnected.
Line is disconnected. Result is this, my lord. My entire plant has come to a standstill.
When?
My lord, it has been disconnected on the 22nd July. Page 6. Kindly, my lord, take page 6 of this bill.
27th July.
22nd. 2-2. My lord, kindly take page 6 of this. On the basis of this bill,
So you want reconnection and hearing of the appeal.
yes, I want, my lord, reconnection in hearing of any day your lordship wants.
Learned Advocate General, how much is due?
Your Lordship, if Your Lordship will see the cause list, my Lord, just see the cause list, my Lord. And in cause list, Your Lordship will find serial number 7, Burnie Heart Industries Association, my Lord. BIA, Your Lordship will find. And then thereafter, my Lord, the petitioners are, my Lord, 8 to 13 are member of 8 to 14 are member of BIA, my Lord. So first, the association files the petition, my Lord, and then the members file the petition separately, my Lord. So both are not maintainable, one, my Lord. Second, my Lord, is if Your Lordship will see in BIA, there is no challenge to the tariff order, my Lord. There is no challenge to the tariff order. Tariff order is valid for financial year, my Lord, from 1st April to 2024 to 31st March 2025, my Lord. And all members have cleared the amount except for 2, my Lord, which I am told, my Lord. This one is, my Lord, payment has not been made by one of the respondent, that is Mathan, my Lord. Mathan alloys in item 14. And Sham Century has not preferred any appeal against the order of the learned single judge, my Lord. So therefore, as on today, my Lord, we are collecting the tariff in terms of the tariff order. That tariff order has been upheld by the MSCRC. What learned single judge held, my Lord, that there is an alternative efficacious remedy, and therefore you avail the remedy if you are aggrieved with this order, my Lord. So therefore, they have been trying to sabotage. They filed review, my Lord. They obtained review, but there is no challenge to the review order also before Your Lordship. There is no challenge to that. If Your Lordship will see the prayer of the petitioner before the learned single judge, my Lord, that's at page 66, my Lord. Sorry, page 39, my Lord. The challenge is only to the recall order.
How much is due, Mr. Advocate General?
Well,
So far as there is the question, because why due, I am not able to clearly state for the reason, my Lord, that in the BIA, my Lord, there is no challenge to the tariff order. If there is no challenge, they are paying they have to pay the tariff in terms of tariff order. And if Your Lord will see the entire.
We are not making any statement with regard to the tariff. How much is due?
My Lord, because they have not made any statement, my Lord, in the entire petition. How do I? Because the question is, my Lord.
Well, may I assist the learned Advocate General on this issue?
Liable to pay 7.5 crore rupees, my Lord. One company, and the another is Pioneer is 3.5 crore. These are the two companies, but so far as Sham Century is concerned, there is no challenge, my Lord. So therefore, their case is not before Your Lord.
Well, may I submit to Your Lord? Kindly come to page 6. I hand it up to Your Lordship.
Pioneer is only 3.5, my Lord.
Yes, that's right. I showed to Your Lordship.
Pioneer is only 3.5,
this is the
my Lord,
bill. This is the last bill which has been given. And my Lord, kindly.
3.5, my Lord. Pioneer is only one company which is before Your Lordship, and the amount due is 3.5 crore.
I am appearing for Pioneer in this appeal.
In Pioneer,
I am
my Lord,
appearing for Pioneer and Mython.
Pioneer, my Lord, review was dismissed, and Pioneer has not challenged that review order also, my Lord. There is no challenge to the review order, my Lord.
Yes, yes.
So therefore, before Your Lordship, there is no matter, my Lord, because what is because what they say that the Commission has no power to pass the order, recall the order, and then thereafter, my Lord, and the tariff order cannot be issued. Tariff order has been issued under Electricity Act. Your Lordship, my learned senior counsel is correct that previous tariff order was up to 31st March. From 1st April, there has to be new tariff order. Now on that ground, my Lord, they cannot come and say that I will not pay the tariff in terms of tariff order, my Lord. And the learned single judge has considered the entire aspect. Only I will two paragraphs of learned single judge. What was their argument before the learned single judge? Kindly see 2 paragraphs, my Lord. Mr. Paul has argued, my Lord, before learned single judge at page 506, my Lord, para 3.
If they indicate their dues, you will pay.
Well, may I indicate to my Lord, my Lord, kindly, my Lord, take the kindly take the paper book, my lord. This application which has been made before your lordship, kindly come to page 59. This is the order. This is the order which was
application, my lord,
subsisted.
I have not received, my lord. This application probably has been filed now only.
No. This. I'm
Lordship,
showing
have it on Monday.
showing the
I will
application which has been
please-
served. I'm showing the application which has been served. Page 59. My lord, kindly come to page 63. This is the order 11th April 2023, in terms of which, my lord, up to 31st of March 2024, this was prevailing. And kindly see the order, the last sentence at page 63. Last sentence of the order. This order shall be effective from 1st April 2023 and shall remain in force till 31st March 2024, or, kindly note, till the next tariff order of the Commission.
Page.
Page 63 of the paper book, or of the thick one. In the memo of appeal, your lordship will be pleased to see this. Has your lordship got page 63?
Yes.
This is the order of 11th April. This is a subsisting order. Nobody has challenged. We have paid it. And my lord, kindly see page 63. This order shall be effective 1st April 2023 and shall remain in force till 31st March 2024. Your lordship has got that? Or till the next tariff order of the Commission. Now, what I am submitting before lordship is this next tariff order of the Commission, which was of 5th and 6th of June 2024, that was, my lord, set aside. That was recalled. And, my lord, a fresh tariff order was passed, and that order I've told your lordship is on the, my lord, 3rd August 2024. Sorry, 24th of October 2024. The Regulatory Commission, that is, my lord, kindly come to page 170. This order, my lord, is sought to be made effective with retrospective effect.
Mr. Mitra, what interim order you are praying for today?
Well, I am asking for this, my lord. Kindly direct them, my lord, to restore my electricity connection. I shall, that they have, my lord, raised this particular.
No, but you should make some payment.
Of course, I shall have to make payment. What payment I have to make? This is why I showed to your
It's all
lordship.
right. It will be just ad hoc.
The interim
Mr.
order-
Advocate General, you tell us.
Well,
what
may
to
I
do.
submit this? My lord, this particular area.
Subject to Advocate General taking complete instructions, it will be a 1 week, 2 week arrangement. We will bring the matter back.
Lordship. Very well.
But how much they should deposit?
My lord, Pioneer is due is 3.5 crore rupees, my lord.
Forget
Straight
about
away.
Pioneer or Souvenir.
Because we-
You say how much money they should put in, Mr. Mitro's client, with the electricity regulatory.
If I
No, it is with the
Senior
distribution
Minister.
company. It will go to the distribution company.
What did say the Advocate General? Yes.
Let the advocate general say. Yes.
Yes, my lord, the money will go to the distribution companies, my lord.
Yes.
The problem is, my lord, why I am not able to indicate the figure? Why? Because, my lord, all consumers are including paying as per tariff order. My lord. This tariff order.
No, that is all right. It is an ad hoc payment subject to your they making a proper calculation and forwarding it.
So, my lord, because therefore I have to take instructions.
But may
in
I
respect
make this
of-
submission?
Yes.
By way
I
of
have to
an
take
interim
instructions in
order,
respect
your
of-
lordship
because
can
they have not
say this.
stated any amount.
Well, this area had been directed by the Regulatory Commission to be paid in 9 installments. I did not pay the installments because review application was pending, and my lord, interim order was continuing, and interim order was till July. My lord, may I, my lord, pay, my lord, 1 installment of it is about 35 lakhs. I shall deposit 50 lakhs immediately.
Lord,
Rest
Lord,
of the,
they have to
electricity.
they for see this order they have to pay from 1st April 2024, my lord. And
This is
1st
what I'm
April to
challenging.
31st March they have not paid the amount, my lord. And that amount has not been paid, and that has never been under challenge, my lord. In
No,
review,
this
they
is what has been
challenge it, and
challenged.
review has been dismissed, my lord. Review has been dismissed, and that order is also not under challenge.
And my appeal is
Kindly see
that
the review order. The
I
review
prefer the
order,
appeal.
kindly, my friend will place that review order before your lordship. Kindly see page 2, paragraph 2 of the review order, which is not under challenge, my lord. Which is not under
no,
challenge.
review
Paragraph
order
2 of the
can't be
review order.
challenged. That can't appeal doesn't lie. I preferred an appeal from the
The review and the against that
writ
review
order.
and final order.
That
both
appeal
are
is
to be
before your
challenged.
lordship, which is being heard. The appeal, my lord, I think, my lord,
with greatest respect,
I have not been able to make, this is my default, my lord, I shall tell you, lordship.
You filed a review application before the commission.
Yes,
before the
no,
Before the learned
before the
single
court, the trial court. The court said
Before
that
the
you have
learned
preferred
single
an appeal already, therefore I am not going to entertain your review petition. So this is the appeal before lordship. So the appeal is pending, review petition has been dismissed because, my lord, the appeal is pending before lordship.
So what was the
No, my
interim
lord, kindly
petition
see,
you do?
kindly
The
see the
interim
review
order,
paragraph two.
before that
Paragraph two of the
dismissal
review
took
order.
place, my lord, interim order is, my lord,
Mr. Paul Leonard, Senior Counsel,
this is at
assisted by
page
so and
382.
so, submitted that though this court, while passing the common order of 2nd June 2025, had interfered with tariff order of 5th June and 6th June passed by Meghalaya State Electricity Regulatory
In the
Commission.
interim,
thus effectively making
it is
tariff order
provided
from
that the
11th April
electric
as
connection to the
only
plant
order that is
commissioner
applicable.
shall not be disconnected. That was the order.
And has resulted in error apparent on the 5th, which calls for review of the judgment of
The
2nd.
judgment
It is
of
further
judgment.
submitted tariff order of 11th April remains only order which will be applicable to parties, and they ought to be
This is the
allowed to
interim
avail the
order.
tariff as per order of 11th so and so. London Senior Counsel submitted those again the instant order which is sought to
You
be
had
reviewed.
challenged the tariff order 31st March.
My lord,
31st March. That order was up to 31st March, and after that, my lord, there is a tariff order which is applicable, and they are paying in terms
this
of all
tariff order
members
I
are
am
paying,
challenging. I am
except
saying
two
that
of-
you didn't have
except two members are
jurisdiction
not
to do
paying,
so.
my lord. Except two
before
This is
members.
not happening of challenge.
Before the learned single judge, which tariff order you had challenged the tariff order dated 31st March 23?
No. My lord,
They
24th
have not
October
challenged any tariff
2024.
order, my lord. In
Well,
the BIA, there is no challenge to the tariff order. That is what I
I
wanted
think,
to show, my lord.
24th October 2024, I tell you, lordship, the
There
regulatory
is no
commission
challenge.
issued fresh tariff order reviewing its rates with effect from 1st April 2024. I challenge that, my lord, before the learned writ court on two grounds. That, my lord, there was no authority of the commission to, my lord, recall its earlier order, number one. If that is, in the alternative, I have also submitted that in any event, the regulatory commission could not have passed any order with retrospective effect. That means, my lord, and no order could have been passed on 24th October 2024 with effect from 1st April 2024 And that is the
Kindly see the
subject matter
prayer,
of
my
challenge
lord.
before your
Kindly see the
lordship.
prayer. Kindly
That's
see the
subject
prayer, my
matter
lord.
of
Kindly
23,
Page 39. Page 39.
Referring to some other.
But tariff order is 24th October 24.
Yeah, 24th October 2024, page 170 of the paper book.
And the impugned order?
The impugned order is 24th October 2024. No, 24th October 2024 is the regulatory commission's order, which I challenged by your affidavit. And my lord, the impugned order is 2nd June 2025.
Only in one matter.
In which, my lord, a
challenge, my
review
lord.
application
This
was
matter
made, and in
all
that
matters
review
that are
petition, my
not
lord,
challenged.
this interim order was passed. Kindly see.
It's given already. So we
My lord, kindly
Kindly
see.
see the order, the prayer at page
This is the
39.
interim order which was passed.
That is why I discourage this virtual courts. All at the
May I have
same
it
time
on
buffering.
Monday, I will be there, my lord, personally Monday. Your lordship, list this matter on Monday because this connection has taken place. I will take instruction also, my lord. Monday, your lordship, I will be physically present.
Then don't disconnect my
Monday,
electricity.
He's already
this connection has
disconnected.
already taken
It was
place.
disconnected. And in spite of the order of court.
Monday, your lordship will have the clear picture, and on Monday I will be there, my lord.
My lord, kindly see their own bill, what they are saying. They are saying, my
Monday's
lord,
lordship,
the due date of my lord, due
Monday
date of payment is 31st July and disconnection date 1st August. They themselves are saying, my lord, in their bill.
Mr. Paul, what you were submitting?
It's just two issues. Just to supplement on facts, Willis. Sir, with your
Yeah,
permission.
bolo.
Willis, the bill was raised on the 17th of July, indicating that the last date of payment is the 31st of July and my lord's date of disconnection is the 1st of August. That my lords would find at page 6 of that supplementary.
Bill 17th July.
17th July.
Yes.
Last date of payment is 31st of July.
For this installment,
Date of
one
disconnection
installment.
is 1st of August. It is there before my lords. They have gone and disconnected my electricity on the 22nd of July, my lords. Even though the bill says date of disconnection is 1st of August. That's one part. And what my learned senior was trying to point out, my lords, is even after disconnection on the 31st of July, my lords, we have made a payment of rupees 3 crores 12 lakhs. That is the last page of that supplementary affidavit which has been placed before my lords. The current dues, we have paid it.
Up to, my lord, kindly see this particular, the last annexure, my lord. We have paid
okay.
more than 3 crores, my lord, on the 31st of July.
No, to get the other facts correct, the tariff order was 24th October
2024.
with retrospective effect from
1st April 2024.
which was challenged in the writ.
Yes, my
Yes.
No, my lord, in only one writ. It was challenged in only one writ.
I
DIA
think
has
my
not
learned
challenged it.
friend here is referring to a separate paper book. We are at item number 14, Pioneer Carbide, and at page 53
Pioneer is
is the
only two
prayer
parties,
made in
my
the
lord.
writ
In Pioneer,
petition.
there are two
All right.
parties
Unless we're
only.
interjecting on, my lords, on virtual
Now-
mode like this, it
now-
becomes very difficult.
This writ was dismissed on
2/6/2025.
then review
Then
preferred.
we immediately filed a review on the 16th of
June.
June 2025.
Yes.
And an interim order came to be passed on 17th of June, my lords, which is there before your lordship. I'm sorry, my lords. 17th it was filed, and 18th an interim
18th
order
of
came
June.
to be passed. Do not disconnect electricity.
And they disconnected electricity on the 22nd of June. July. 22nd of July, they disconnected electricity.
What happens on 23rd August 24?
23rd August.
My lords, I write a protest letter to them saying that your bill says it is due on 31st. How have you disconnected on 22nd? That's my first letter, my lords, in that supplementary affidavit.
And apart from retrospective operation of the demand, what other challenge was made in the writ?
The issue, the second issue was whether, my lord, the regulatory commission had the authority to recall its order, which has already been passed, and in respect of which, my lord, the effect has been given on 5th and 6th of June. These are the two issues. The second issue, my lord, I am not very confident about it. But the first issue with regard to retrospective effect, my lord, that has got some substance. My lord, the law is absolutely clear on that. Unless, my lord, expressly or by necessary intendment, a particular provision of a law, my lord, declares it to be retrospective, my lord, no law can be retrospective.
My
And, my lord, retrospective operation, my lord, what is...
May I place, my lord? Kindly see review order, my lord. Kindly see review order, paragraph 6. Filed by in item 14, my lord. Kindly see the review order.
My lord, I am submitting, my lord, that is why I said short submission.
Yes.
As my learned junior
Your
has
item
pointed-
is item number 14.
Yes.
Item 14.
My lord, I submit to your lordship, my lord,
Item
but
14,
give me
my
2
lord,
minutes.
kindly come to
But
page
if my lord
446,
kindly allows me,
446.
I say that
446,
you yourself say in your bill that the due date of payment is 31st July 2025. You yourself in your bill, you say that disconnection date will be 1st August. Then how can you disconnect it on the 22nd of July? Before the due
My
date
lord,
comes?
kindly see page 446, my lord.
How
Only
much
one
time?
paragraph.
All right. How much time it will take for you to take instructions?
My lord, kindly have it on Tuesday, my lord. I will take instruction on Tuesday.
Mr. Mitra,
Will,
you can-
if your lordship so want.
you can appear physically or online, whichever you like.
Whatever is there.
Whatever-
I shall see, my lord. What.
Yes, that you decide. Huh?
But in the meantime, may I submit this? They themselves are saying, my lord, 35 lakhs or
No, my
so
lord, it's
by
not
way of
correct, my
installment
lord.
is payable.
Mr. Mitra
They
has
have, my
not been
lord,
correctly
divided
briefed.
up the
Has
whole
not
thing
been correctly briefed, my
the
lord.
entire
I'll show
amount
before
of
the
due
record.
into 9 installments.
And that is what Learned Single
Last
Judge has recorded
installments,
in the
I have
review
paid
order.
33
That is
crores
what
and all
Learned
in
Single Judge
July.
has recorded in the review order.
Now, my lord, I
That they
shall
are
deposit,
abusing the
my lord,
process
one
of law.
installment of the arrear. As my lord,
My lord, kindly have
with
it
the
on Tuesday,
regulatory
my lord.
commission. And that is
Kindly
about
have it on
35
Tuesday.
lakhs. I shall
I'll
deposit
clarify.
35 lakhs.
Kindly have it on Tuesday, my lord. We will clarify everything, my lord.
And restore my electric connection.
Because that would amount to allowing the writ petition, my lord. Restoring electricity means writ appeal.
Meet the demand of the suppliers. So we are under contract to supply to certain PSUs because of the electricity required.
Reconnected, subject to resulting order.
But by reason of this disconnection, I am, my lord, committing breach of contract
My
with
lord,
my.
Before
with my
amount to
Please
allowing
take
the
up.
writ appeal, my lord, I will have it on Tuesday. We will also have passed comprehensive order.
This is an appeal from a judgment and order dated when was the review dismissed?
The review dismissed on 17th of June. 18th of
July.
18th of July, sorry. It was filed on 17th June, dismissed on 18th July. And the interim orders were vacated.
Yes, 18 July. From that you are preferring an appeal here.
No, I have preferred appeal from the main writ petition.
All right.
The
There is
order
no challenge to review order. There is no challenge to review order.
All right.
By the way, in front of him, I should not say it.
I have brought these facts on record.
2nd June. From a judgment and order,
Supply copy.
I repeat, this is an appeal from a judgment and order dated 2nd June 2025, passed by a learned single judge of this court on 2nd June 2025, comma, dismissing the writ petition. Full stop. There were various grounds made out in the writ petition, amongst which the most important were the power of the Central Electricity Commission, the Meghalaya State Electricity Regulatory Commission, to increase electricity tariff retrospectively and to alter the tariff without just cause. Paragraph. At this stage, we are not going into the details of this matter and reserve our right to do so at the next hearing. Full stop. Suffice it to say, at this point of time, that an application for review of the said order passed by the learned single judge was filed before his lordship on 16 June 2025, on which an interim order was made on 18 June 2025, restraining the Meghalaya Power Generation Corporation Limited and the Meghalaya Power Distribution Corporation Limited, Meghalaya Power Transmission Corporation Limited from disconnecting the electricity supply of the appellant. Now, this review application was dismissed by His Lordship on 18 July 2025 on the ground that an appeal had been preferred before us. Full stop. The interim order automatically stood vacated. Paragraph. Although the respondent corporation had raised the bill on the appellant on 17 July, where the last date of payment was indicated as 31st July, with the threat that disconnection would be effected on 1st August, comma, after the dismissal of the review application on after the dismissal of the review application on 18 July, they rushed to disconnect supply on 22nd July. Paragraph. We have requested Learned Advocate General to take specific instructions as to how much is due and payable by the appellant to the respondents. Mr. Jayanto Kumar Mitra, Learned Senior Advocate appearing for the appellant, states that in the impugned order of the Commission, before this court, it had directed payment of the dues by installments of rupees 35 lakhs per month.
It's not 35.
Full stop. He submits that substantial payments have been made during the pendency of this litigation before this court, comma, the particulars of which are to be furnished at the next hearing of this application. Full stop. He states that his client be permitted to deposit one installment amount of rupees 35 lakhs and electricity be restored as an interim measure subject to further orders that may be passed in this appeal. Paragraph. After considering Learned Advocate General opposes this.
One submission, my lord, at this juncture, my lord. 35 lakh, there are about 7-8 companies, my lord. Now, Mr. Mitro is saying in respect of which company he is going to deposit.
Commission has said 35 lakhs or not?
No, Commission has not said so, my lord. That is what I am saying, my lord. It's not correct. That's a problem, my lord. A Commission has not said 35
so
lakh.
it is on record, Mills, that the
35 lakhs.
dues are to be paid in 9 equal installments.
We are not going. Is it there in the order or not? 35 lakhs.
No, it's
The
not.
competition, it is the Commission
Not there.
does not give a figure. The Commission says whatever is your due, you pay it in 9 equal installments. bill they have generated, my lords, which show 35 lakhs.
And that
All
commission said,
companies.
my lord,
No.
24th
Separate
October,
companies have separate
24th
payments.
October.
All other companies have already paid, my lords. And
Yours is
1 year
35
later.
lakhs.
Yes.
this company is 35 lakhs.
Only I am talking of one company only.
Yes. Learned Advocate
One
General,
company-
Learned Advocate General disputes that the Commission had directed payment of 35 lakhs as installment. As payment by the appellant as installment. Full stop.
my
He
lord,
also
there's multiple appellants.
this becomes very difficult, Mr. Advocate General, at the time of dictating the order.
I'm sorry, my lord, but the problem is appellant, they will say that all of them are
All
appellant.
right.
Only one.
We will only up to Tuesday. We will nothing.
Pioneer Carbide is the company.
All right.
Yeah,
And,
Pioneer Carbide. Kindly mention the name, then it will be all right.
Appellant Pioneer Carbide. Learned Advocate General also opposes the prayer for restoration of electricity supply. Next. Considering the submissions made, we hold the prima facie view that till dismissal of the review application on 18 June 2025, the appellant was enjoying electricity. Full stop. Now, if this state of affairs had continued till 18 June 2025, 18 July 2025, it would prejudice none if the same state of affairs is allowed to continue till this court has an opportunity of looking into the cases of the parties, the rival cases of the parties in more detail. Full stop. In those circumstances, no, full stop. Furthermore, the Commission has directed payment of the adjudged dues in installments. Full stop. Learned Advocate General is to seek the exact outstanding amount as of date in terms of the Commission's order, taking into account the payments made by the appellant. Paragraph. Considering all these circumstances, let the electricity supply of the appellant be restored temporarily, subject to further orders to be passed by this court upon their depositing, upon the appellant making a deposit of rupees 50 lakhs with the
Distribution company.
Meghalaya Power Distribution Corporation Limited by
In the course of the day.
I shall deposit in course of the day because my restoration has to be done.
by 8th August 2025. Full stop. Restoration of electricity is to be effected today, subject to the payment being made by tomorrow. A list.
And this payment is without prejudice to my rights in the appeal.
The payment and recollection
Yes.
are without prejudice to the rights
Rights
and
and-
contentions of the parties. List this appeal and application on 12th August.
12th August.
12th August. Lordship.
The reconnection, my lord, by tomorrow.
Huh?
12th
Connection
August.
by tomorrow, because they will deposit, because we have some technical, these are heavy industries, my lord. So then it will take
Alright.
some time, my lord.
Restoration of electricity by tomorrow.
Subject to.
By tomorrow 2 p.m.
Yes, my lord. Yes.
Not that they will come rushing on Saturday to the residence and say that, oh, what?
No, my lord. Once order is passed, they will reconnect.
Only you take instructions,
We will do that.
don't worry about.
Yes, my lord.
Lordship. Well, great. to
Yeah.
Number 4 and 5.
Ali pledge. Looks like other connected appeals can also be listed on the same day.
The other connected appeals also.
The same point. Same point involved in everything. All.
There are eight appeals.
Item 7 to 13, my lord, so can just be listed on the same day. There's no disconnection. So I'm not praying for an interim, my lords, only list on along with source.
All right, 7 to?
13, my lords.
All right, 7 to 13, separate orders from the same judgment and order.
Same judgment.
Same
Same judgment and order.
Appeal admitted, list on Tuesday.
That is, Ali pledge.
You write there, no scope of any interim order as there is no disconnection of electricity supply. No interim order for at this stage. Yes.
My lord, on the day before yesterday, my lord, I argued regarding the affidavit that the government has filed, and I raised certain objections with regard to that.
Yes, yes.
In support of
The authority of the person affirming the affidavit.
yes, my lord, I am placing a judgment of the Honorable Supreme Court on this point, my lord. My lord, the citation of the case is 2011, Volume 7, SCC, page 69. Volume 7, SCC. It's page 69. My lord, may kindly come to page 77 at paragraph 17. May I start?
Yes, yes.
Here we may point out the casual manner in which the petitioner approached the court. The affidavit filed by the petitioner in support of his petition and relying on which this court issued notice on so-and-so is not at all modeled either on Order 19, Rule 13, Rule 3 of the CPC or Order 11 of the Supreme Court Rules 1966. The relevant portion of the affidavit runs as under. My lord may skip over that part. Paragraph 18. The provision of Order 19 of the CPC deals with the affidavits. Rule 3.1 of Order 19, which deals with matters to which affidavit shall be confined, provides as follows. Matters to which the affidavit shall be filed shall be confined to such facts as the deponent is able of his own knowledge to prove, except on interlocutory applications on which statements on his belief may be permitted. provided that the grounds thereof are stated. Order 11 of the Supreme Court rules deals with affidavits. Rule 5 of Order 11 is a virtual replica of Order 19 Rule 3.1. Now, Order 9, the High Court rules of 2025 and 26 are also, my lord, practically virtual replica of Order 19 Rule 3 in the CPC. The Order 11 Rule 5 of the Supreme Court rules is therefore set out. Affidavits shall be confined to such facts as the deponent is able of his own knowledge to prove, except on interlocutory applications on which statements on his belief may be admitted, provided that the grounds thereof are stated. In connection with Rule 13 of Order 11, the aforesaid rules is also relevant and is set out below. In this order, affidavit includes a petition or other document required to be sworn or verified, and sworn includes affirmed. In the verification of the petition, pleadings or other proceedings, statements based on personal knowledge shall be distinguished from statements based on information and belief. In the case of the statements based on information, the deponent shall disclose the source of his information. Well, that is the exact expression is used in the Rule 25 and 26 as well. The importance, paragraph 21, my lord, that's very important. The importance of affidavits strictly conforming to the requirements of Order 19 Rule 3 of the Code has been laid down by the Calcutta High Court as early as in 1910 in Padmavati Dasi versus Rasiklal Dhar. An erudite bench comprising of Lawrence Jenkins and Woodruff laid down the law as follows. We desire to impress on those who propose to rely on affidavits that in future the provisions of Order 19 Rule 3 must be strictly observed, and every affidavit should clearly express how much is a statement of the deponent's knowledge and how much is a statement of his belief. And the grounds of belief must be stated with sufficient particularity to enable the court to judge whether it would be safe to act on the deponent's belief. The position was subsequently affirmed by a constitution bench of this court in State of Bombay versus Purushottam Jognaik. Vivian Bose, just speaking for the court, held, we wish to, however, observe that the verification of the affidavits produced here is defective. The body of the affidavit discloses that certain matters were known to the secretary who made the affidavit personally. The verification, however, states that everything was true to the best of his information and belief. We point out that as slipshod verifications of this type might well in a given case lead to rejection of the affidavit. Verification should invariably be modeled on the lines of Order 19 Rule 3 of the CPC, whether the code applies in terms or not.
Please come to the next point, Mr. Datto. We will give you leave. If you so want, we will give you leave, but don't, we are paucity of time.
No, my lord.
You'll write under the Right to Information Act that you confirm whether this information is correct or not.
No, my lord.
6% work, 6% work done. This is the value. This is the payment not made up to now.
My lord, that is not my case. My case.
We will make it your case, Mr. Datto.
No, my lord,
but this we will not allow.
My lord, this way, my lord,
What is all this?
My lord, with all respect, I am submitting, my lord. This way, my lord, the case has been given a dimension much beyond what it was before the Honorable Secretary.
Very good. You are purposely trying to ensure that I don't complete this case in my tenure.
No, my lord.
What is all this?
My lord, your lordship had permitted. It was your lordship's order.
Next point.
It was.
Come to the next point. You are sufficiently senior, sufficiently knowledgeable.
My lord, it was
sufficiently knowledgeable. This is just in cricket it is called blocking practice.
No, my lord.
That's all.
That is absolutely not.
Block 15 overs and the match will be drawn.
That is absolutely not the case, my lord. Your lord, my lord, kindly bear me.
No, kindly you come to your next point. This affidavit point is rejected. Finished. Now you come to your next point.
My lord, may I just make my submission on this?
No.
Your lordships have your lordships directed.
An affidavit has been filed. We have noted your submissions that the officer had no knowledge. 2-3 officers at different points of time had made assertions.
No,
that's all.
My lord, that is a rider, my lord.
Yes. Now all over the world, arguments are made time bound. Petitioner 1 hour, respondent 1 hour, reply half an hour.
My lord, I have not even opened my case, my lord. I am replying.
If this is the opening and closing, then we will close your case just now.
My lord,
and make it CAB.
My lord, your lordship.
You come to your next point.
My lord, I am coming to it. My lord, your lordship will kindly remember there are 2 appeals I am to answer. 2 appeals.
What kind of a case you are citing? There is no consciousness to do substantial justice. They are just going harping on
No, my lord,
technicalities. Maybe Supreme Court judgment.
My lord, in this case, my lord,
What should an affidavit be? Knowledge, submission, this and that. Where is the substantive justice here?
no, my lord, the question is substantive justice is that Honorable Court asked the deponent of the case to file a fresh affidavit in accordance with law.
And thereby waste time.
No, my lord, that is of course, my lord, that observation is not warranted in the case.
Just see the paragraphs.
My lord,
We are not prepared to do this kind of justice here.
now, if your lordship is,
99, Lord Jenkins, this and that,
No, my lord,
all screwing.
my lord, this is of
technical
2011.
point.
This is of
Maybe,
2011.
but references to those judgments.
And my lord, this judgment of 1910, my lord, 3 constitution benches have upheld it, approved it. My lord, and the strict emphasis is that, my lord, the affidavits, in order to rely on the statements, my lord, tomorrow if your lordship is going to rely on the affidavits filed by the MEPGCL, Lord,
I am telling you, we will give you leave.
my lord, I am not on the leave, my
your
lord.
trial leave, you apply under the Right to Information Act and seek information from the office that whether this statement made in the affidavit with regard to the percentage of work done and when the work started, when the work was stopped, is correct or not. You will get your answer in 7 days from somebody else.
No, my lord, I am not on that. I am on the admissibility of the affidavit itself. Whether or not the facts stated therein are correct or not, your lordship is going to...
You bring an affidavit with that reply you get from the Right to Information Act. And if it says that the facts stated in the affidavit of the state government is erroneous.
My lord, tomorrow I will make an application. Your lordship will kindly direct them to give me a reply.
Yes,
I'll bring it on with an affidavit.
Then we will reject that affidavit and think of also starting proceedings in perjury. But you please come to your next point. No more time.
I am coming to the next one. Your lordship may kindly grant me that liberty, my lord. Tomorrow I will make an application. Today I will make an application to them.
You make an application, your tribunal will make. You proceed with your argument.
But my lord, in that case, if your lordship is deciding the matter finally without waiting for the response, my lord, in that case it will become an empty formality.
We have to do justice. Because your client thinks that the order should be in a certain way. That doesn't mean that that 10 hearings will be wasted and the matter will start de novo.
My lord may kindly.
We are telling you, come to your next point. Will you or will you not?
Well, I am certainly ready
Please
with
come. If
the
you have
other
any
point.
other point, come.
Well, Lord, one more paragraph I will just read out to your lordship, my lord. Your lordship will kindly bear with me. Well, there is a set of rules made by the High Court. Can your lordship, my lord, will your lordship kindly permit this? If I tomorrow bring out a piece of paper out of my pocket and pass it on along with an affidavit,
today I will take out 99 out of 100 affidavits filed in this court and in all other high courts in the country and also in the Supreme Court, where we will find that they are absolutely defective in terms of the rules.
That is why, my lord, if it is defective, my lord, whether your lordship is going to place reliance on it.
But then so much of energy, so much of time and so much of is not wasted on that.
Well,
if there is evidence to suggest that it is perjury, an application under 340 CRPC is made.
Well,
but not in this way.
My lord, that's why I am saying, my lord, tomorrow your lordship grant me permission. Today, my lord, today I will make the application.
Where is your prima facie case that the information is wrong? Where is your prima facie case?
My lord, first, before I say my prima facie case, my lord,
we don't have to tell you that there is a presumption in the Evidence Act that any information obtained from government office, any thing done is presumed to have been done regularly, unless it is proved otherwise.
True, my lord.
But where is your proof to the contrary?
My lord, in my respectful submission, my lord, my chance of putting the proof will come only when your lordship accepts the evidence as, accept the affidavit as true.
Once you adduce proof,
only then, my lord.
Once we adduce proof, we will reject. Where a single picture you have not been able to bring that no construction has been done, and swear an affidavit, going on and on and on to see that this matter is not decided.
My lord, the other day also I said, 15th of February the work order is issued. There are post-tender conditions requiring to be fulfilled, and they say that 16th of February the work commences. How then can be taken as
taken
correct?
Note of.
That's why, my lord, I am saying.
We have taken note of that. There are 3 notebooks.
That's why, my lord, I have said.
Or any other point except this hyper-technical this affidavit point.
My lord, I'll just take your lordship to the work order once more. My lord, that will demonstrate, my lord, whether this affidavit they can be considered as a true and genuine. Okay? Your lordship will kindly come to page 121. Page 121, my lord, they require the contractor to come with a letter of acceptance within a period of 7 days. Page 121 is dated 15th of February. Now, at the same page, my lord, the fourth paragraph, they say that before you come to sign the acceptance part, you comply with the 4 other requirements. The requirements are namely, and the caution sounded is that these formalities have to be fulfilled before commencement of the work. If your lordship will kindly bear with me, my lord, 121 paragraph 2, if your lordship will kindly see. Page 121 paragraph 2 and 3. Paragraph 3, my lord. Please attend the office, as your lordship got it. Please attend the office of the undersigned in any working days during office hours for signing the tender agreements in so and so form before starting the work. Then, next, but 1, you are requested to obtain the certificate from the Registration and Licensing Officer, Building and Other Construction Workers Act, Office of the Labour Commissioner, Meghalaya, before starting the work.
Will you kindly come to the first paragraph?
Lordship?
Will you kindly come to the first paragraph?
Yes. First paragraph says
May I
that...
read it to you?
No, my lord, I'll read it to your lordship.
Inform you.
This is to inform you that your tender has been accepted, yes, for construction so-and-so has been accepted by the department and the work is allotted to you.
Your e-tender, that is your offer, has been accepted by the department.
Yes. And
this is where there is a contract formation.
Yes.
And the work is allotted to you.
Yes.
For execution as per your quoted rates, etc.
Yes.
The rate is also mentioned here at 2 crores something something.
Yes.
Your letter of acceptance to execute the work
should be intimated within 7 days from the date of issue of the order.
The work should be started immediately in consultation with the so-and-so. And the rest are all other paraphernalias.
Now in the rest, my lord, there is a rider, my lord. Before you start the emphasis is before you start execution of the work. My lord, it is in paragraph 3, it is very clear that these formalities have to be completed before starting the work.
Yes.
Now, have I been able to convey that to your lordship, my lord? Now, 15th is the Thursday. The work order is issued on 15th, and in the affidavit, they say that the work commences on 16th. My objection is because of this, my lord. Can by their sweet will they pass on the papers just like that, and they do not vouchsafe for the correctness of it. In the affidavit, they say that this is true to knowledge, belief, records, everything. That's why, my lord, I am citing this decision to put emphasis that, my lord, in order to enable the honorable court to take notice of the facts.
You have filed a rejoinder to that affidavit.
Yes, my lord.
You have taken that point.
Yes. I'll just read it.
You have mentioned this.
Lordship?
You have mentioned this, that it could not have started on 16th.
Yes.
All right. Paragraph.
I am just giving it to your lordship. Your lordship may kindly come to paragraph D at page 5. Rather, your lordship can see it from paragraph C.
Raise these points. That's all. Rejoinder paragraph
C.
All right.
Paragraph C and paragraph D.
All right. This matter is also there tomorrow. We will continue tomorrow?
Yes.
Mr. Datta, this is a much better point.
Well, in my formulation, I was just trying.
Very sad to say, earlier, you read this section 5 cases. Shocking, absolutely. Explain 1 minute's delay, explain 1 second's delay, what happened there and then. Thereby, They did no substantial justice.
No, that is.
And only on technicalities, this thinking that few long cases would be reported in in most premier journals, and these judges went on.
Section 5, my lord, with all respect, my lord, I'll submit. Section 5 stands on a different foot.
No, in other things also. Like technicalities were put above the law, and instead of being handmaids of the law, it became deterrent.
But here, my lord, if this kind of a thing has been brought on record, my lord, my responsibility
Otherwise,
is to
why should the same Supreme Court started accepting public interest litigation in postcards? They could have said, where is the affidavit?
My lord, in that respect, my lord, I am constrained not to make any statement, my lord. But so far as the inter-party litigation, my lord, PIL is not an adversarial litigation. This is an adversarial litigation, my lord. Perhaps, my lord, the reason lies there. In an adversarial litigation, my lord, the requirements of following the procedures of law must be on a different
Why
footing.
do we accept reports by government officers, properly sealed and signed in courts? In every such case, we could have said that you swear affidavits and come to court, thereby delaying matters.
My lord, but one thing must, my lord, at the end of the day, my lord, one thing.
Why in demolition cases we see photographs in court? We trust the learned counsel that he is not showing.
No, that is true, my lord. But then the kind
photographs.
But the bare minimum requirement,
Yes,
in
that
my
we have
respect.
noted, Mr. Datta. Come to your next point. This is good. 15 February. How could the work start from 16?
Yes.
Come to your next point tomorrow.
Yes.